Without further ado, I'd like to pass the mic over to Anita Ramasastry, member of the Working Group for Business and Human Rights. Anita, you have the floor.
Great, thank you so much, and good morning to everyone, or good afternoon. My name is Anita Ramasastry. I am a colleague of Professor Surya Dev, who you've heard from today, who is the chair of the Working Group on Business and Human Rights, and it's my pleasure and honor to be with you here today. So thank you for the opportunity. This leading panel is meant to really explore a concept which I find very technical in some ways and very abstract, which is this idea of human rights due diligence, which comes from the guiding principles and is meant to be a process that businesses put in place to make sure that they do respect our human rights in their activities. And of course, you've all been discussing in your local hubs, what are the kinds of impacts that are caused and the harm that business potentially causes. And so human rights due diligence, as we've talked about, is meant to, businesses are meant to look and identify in advance what kinds of harms are connected to their business activity. And then through due diligence, they're meant to prevent and mitigate those harms, and of course, provide access to remedy. Now, this is, of course, a large challenge. Today's panel is going to focus on something called mandatory human rights due diligence. In certain countries in the world, many in Europe, but we'll hear about some other experiences in South Africa and India during our panel today, we're seeing governments step forward and actually require human rights due diligence. So they're requiring businesses to take into account their human rights impacts as a matter of regulation. What that looks like and whether it's effective still remains to be seen. And most interestingly, the European Union has announced and is in a process now of creating something for all of the European Union member states to require human rights due diligence. So a regional effort as well as national laws. Now, many of these laws are meant to have effect outside of their country, meaning, as we've discussed in this forum and in others, that if there is a business that's operating internationally or in other markets, that obligation to respect human rights should carry forward to those other places. So if we think about the Pacific and companies that are engaged in foreign investment activity, whether it is mining, whether it is tourism, right, that they have that same obligation at home, but wherever they are operating, and their business partners as well should do so. That is the sort of international context for our discussion, but there is the local context, which is, if we think about different countries in the Pacific region, what do we want in terms of, or what do you want, I should say, as the rights holders to be the models? Should there be requirements on companies for due diligence? Can there be? And if we think of local or national companies, if we think of small businesses or informal businesses, what would this really look like? And so there are many challenges we have to talk about bringing these concepts into our own countries and local geographies. So we'll talk about that as well, the challenges, the opportunities, and what the global landscape looks like as we address this new trend and this new concept. And so it's my pleasure to really introduce our panel and to hear from them and to hear from all of you about what you think are the promises, the challenges of human rights due diligence as we think about that in the Pacific. So we have several speakers. I'll introduce each one, and they have about 7 minutes for their introductory remarks, and then time for a panel discussion. And at any point, please put your questions in the question and answer box or through chat so that we have a chance to engage with you. Our first speaker, and Tevita, I think we'll begin with you, is Tevita Naikasowalu, who is a human rights and ecological and indigenous rights defender. And I'm going to start with you, Tevita, because really, it's important to think about, from impacted communities and the leaders that represent them, what do you think of the human rights due diligence trend? So over to you, Tevita.
Boleh binaka, Anita? Boleh everyone. Can you hear me well? Well, today I'll be speaking on, this is a foreign issue for us, because mandatory human rights due diligence was almost unheard of. And as far as working with communities in the past 10 years that I've been doing. I'll be sharing my screen so that could help in my discussion. I hope that's on your screen now. I've been talking about this for quite some time. Mandatory human rights due diligence, like I said, to us here, is new in many, many communities. In the picture, you see the children of Wotuamba asking for a safe and clean environment and a future from destruction of black sand mining. Because in the context of this project, mandatory human rights due diligence was not necessarily carried out in its full context. That's why I'm speaking from community-based experiences, and these are from our children in Votua, which I worked with them for the past 4 years. And these children, their voices, they are asking for their rights to be read as children, because the impacts of these extractions, the extraction is close nearby to their home. It's about 2 to 3 minutes away, boat ride. So that is why mandatory human rights is important for our local communities here. Voicing out their voices to protect the children and for a safe, clean environment and for the future from the destruction of extraction. Also on that, the women have been, because they are at the final end of the equation in a household. In as far as extraction goes for black sand mining in Ba, these are the most affected because they are the ones that they look after the family from the morning and during the afternoon and up to till they are the first and the last to go to bed. So from a woman's perspective, this for sure for them is home and life. So it is important for this mandatory human rights due diligence to be a legislative that must be put in place, because it's, like I said, it's new for us. And I'm thankful to the UN and to the organizations for bringing this in so that we can share this and we can share with our community and empower them with this knowledge so that they do have rights and they can participate freely in these developments. This is one of the issue that I say what happens when mandatory human rights is ignored. Like you see in the picture now, this destruction is already taking place. And as we speak, as you can see on the left, these are the affluents from black sand mining going into the sea 24 hours, 7 days a week. And this is like a 2 to 3 minutes proximity from the village. And the loss is great and the damage is great because it's underwater. This is just an example of why we need mandatory human rights due diligence. And the loss of biodiversity and life is also great because it happens in a very fragile and volatile ecosystem. We cannot really quantify well the damages. And what happens if this is still ignored? It reduces inclusivity and people's participation in decision making. You see this, a husband and wife. This is their livelihood. From them fishing here, this is about 1.5 minutes away from the black sand extraction. And these people, they are skill-based. You see a mother and a child and her daughter. She's teaching her daughter how to fish in this kind of environment. And with the impacts of the mining close by, it increases the vulnerability of women and children because COVID-19 taught us that when there was no work in Fiji, especially in the Ba province holds the biggest hospitality tourism trade in Fiji. The only thing that they could rely back on was their natural resources. So in my interview with them, they told me that if these natural resources were not there, they wouldn't have survived. So the vulnerability of women and children increases if we do not put these measures in place. Again, the disregard and disrespect of the indigenous people, Vanua, and their rights. Like, as you know, Fiji is not yet a signatory to UNDRIP, and indigenous right is something that we are really, especially from my perspective, trying to bring up, so that because the indigenous people have the responsibility towards people and creation in terms of how they live and in the way they do their work. So these are two great things that get impacted if we do not carry out mandatory human rights. The loss of this, the disrespect of people, indigenous people, and the Vanua, and also the loss of traditional wisdom, which has a lot of good points and solution in order for us to mitigate the problems that we have on climate change and sea level rise, biodiversity loss. And if we do preserve this, I believe that we have a better footing from community perspective level. That picture is taken 2 weeks ago. I took this picture last year to show what happens. This is one of the biggest gravel extraction in Fiji. In a matter of 1 year, 11 months, you see this beautiful picture here and that picture there. I took this picture in December 2020, and you can see women there are washing and children are bathing in this beautiful, this is the Naikasowalu River, where the extraction of gravels is happening at an extreme fast pace because of the need for development here in Fiji and also for the Pacific. And the impacts of this are swift and destructive, as you can see in the comparison that I'm pointing to in the same river within 11 months. And this ecosystem connects to the sea, and it's not very far away. And the sea is full of reefs and ecosystems. And because this is the main river, it affects the whole ecosystem and the whole communities down way below, even though the community that gave consent for this to happen is this community here. But the effect of this decision affects the whole lot of other communities up to the coastal area and thousands of hectares. So that is why I'm asking if this mandatory human rights is to be a legislative that must be made into our laws and policies, so that this kind of effects can be mitigated and can also be remedied in future. As you can see, these impacts are really great. And that's the bottom of that river. And I took this picture a week ago, and when I crossed this river, I saw that woman, that lonely woman, trying to get fish from the same wounded river. And imagine the impact already having on the ecosystem and already having the lives of women who depended on this river to feed her family, and the chain goes on. So, and for me, I'm thankful to the organization and the UN for bringing this up, because this is an opportune time for us so that we can be included and the particular rights of women, children, live and safe environment, inclusion, inclusivity, disabled people, clean, water safe, indigenous people can all be incorporated in the working of our development plans. So for me, I didn't expect to find this woman there. But when I turned around, I found, and it was quite touching for me, because she was standing here in the middle of the midday heat, and I knew because I come from this kind of area too, I knew automatically that she's finding it hard to get fish from here because of the effects of gravel extraction, and the effect will be felt at home when she goes back to try and feed her family. That's why we stand together. This was also on our. We stood together as a church, NGOs, communities, disabled people. We stood together for communities in crisis, from development impact to address this issue. And I believe mandatory human rights due diligence should be prioritized to communities in crisis from development impact so that to address the issue. Because right now, families are torn apart, clans are torn apart, people are not in harmony, they are in disagreement. There is bad faith and spirit in the community. So if we can use this to address impacts, because the issues are already happening as I speak, as I'm speaking here, this would be a good point for us to bring mandatory human rights due diligence to our companies, to our government, to those who make our laws, and to the organizations like UN to help us advocate for this. And of course, like I've said, it should be mandated in our development laws and policies. And if this, and I say this, most of human rights defenders standing with me here, and this is where the river meets the sea. And in the background there, this is we have what we call the moon reef. This is where one of Fiji's most precious dolphins. Because of the effluent from the gravel extraction, this whole place is covered with mud and debris, and it covers the reefs. And when it covers the reefs, the dolphin moves. And when the dolphin was one of the main attractions for why tourists and locals come here for ecotourism. And like I said, if we can use this to be mandatory human rights due diligence to be mandated in development laws, it can prevent these catastrophes and can also be useful for environmental defenders used in support for communities and bring leaders to attention, like you see this in the picture. And finally, a role of government in enforcing and monitoring laws and policies is necessary and vital for the promotion and service of justice to all. And like I said, instead of increasing our GDP, gross domestic product, I prefer gross domestic peace, because this can only be attained if governments and corporations respect and treats all people graciously and justly and give what is due to them. Thank you very much. That is my
Thank you so much, Tevita. And we already have some questions for you, so you may want to look at the chat, but I'll come back to you for those questions. And there's also requests for your excellent slides. So thank you for putting this together and really bringing us through your visuals, the power of the community in terms of looking at what this means and why we need mandatory human rights due diligence. So thank you. We'll next turn to our next speaker, Dawn Anderson, who's the Economic Justice Lead for Oxfam Pacific. And Dawn, you can also provide us through your work a perspective on what are the impacts that you see in the Pacific region, and what difference do you think would human rights due diligence make in terms of trying to deal with these human rights impacts? So Dawn, the floor is yours.
Wonderful. Thanks very much, Anita. And just checking that you can hear me okay. Some thumbs up happening. Hi, everyone. Well, as Anita said, I'm Dawn Anderson and I'm the Economic Justice Lead for Oxfam in the Pacific. It's such a privilege today to just share with you some brief thoughts. That's all that 7 minutes allows, really, is some really quick, I guess, some quick ideas and quick thinking about what the implications of mandatory human rights due diligence might mean or might look like for the Pacific. And Tevita, I'm so glad that I got to come after your fantastic introduction about what it really looks and feels like. I think it's not an abstract notion. It's not something that sits in theory books. It is the lived reality of Pacific Islanders every day who face the impacts of outcomes and decisions when they don't go well or when they haven't been considered from a rights-based framework. I think we've seen the insufficient uptake of voluntary human rights due diligence measures for too many years. There are a number of mechanisms and processes that are available that can be implemented and that have strong rigor, strong validity behind them, but we've seen companies and governments not able to implement or unwilling to implement those mechanisms and measures. And what we know is that the human rights agenda is won and lost at the negotiating table, at the agreement making, contract making start of the business process. So the idea of mandatory human rights due diligence is exceptionally appealing, I think, in order to bring some transparency, to uncover the secrecy, and to shine a light on what it is that's actually on the table in terms of business outcomes when contracts and agreements are being negotiated. And so what I wanted to do is just really share a couple of examples from other places of where due diligence mechanisms have been applied effectively. And they're very narrow examples. They're not, certainly not from a whole of country human rights framework perspective. They're just some narrow examples. And the first one is, both of them are really looking at the right to free, prior and informed consent, which I think you touched on, Tevita. It certainly is both a fundamental human right as it's enshrined in the UN Declaration for the Rights of Indigenous Peoples, as well as a tool and a process for, excuse me, allowing and exposing the right of people to make decisions about their futures. What can be challenging about free, prior and informed consent as a right is how the term Indigenous is or isn't applied. And also, Tevita, you mentioned if the country isn't a signatory to the UN DRIP, that is another challenge to the application of FPIC as a right. So in certain parts of Africa, the use of the word Indigenous has been hotly contested or is difficult it's not used, it's not considered. It's unsubstantiated, I think. And so research was done across Southern Africa, across a number of countries, really looking at other ways of understanding indigeneity. How can past jurisprudence apply in order to understand where Indigenous rights can be understood and felt and revealed. And what it found was that there are a number of other terms in those contexts that actually are equivalent to the term Indigenous. And so if those terms are applied in legal settings, then actually free, prior and informed consent has a basis for being held to account. And so what that means is that companies and governments then no longer are able to hide behind a lack of a legislative process or a lack of a mechanism. And so what we're finding with a contextualized and localized understanding of an international instrument is in the past 2 years, there's been a number of victories at either local, national or constitutional court level where free, prior and informed consent has been seen to be ineffective or has not been implemented. And so communities are actually winning legal battles against both companies, international companies and local and national governments in order to have their rights realised across the spectrum of the decision-making process. Why that's significant to the Pacific is I think international instruments are excellent, but they can be really blunt when it comes to having a nuanced understanding of either a country, an area or a region. And so the opportunity of mandatory human rights due diligence processes means that there can be localization and contextualization to bring bearing to legal and fundamental mechanisms that can hold governments and companies to account. And the reason why I also mentioned governments in this space is, yes, the mandatory nature might be for businesses, but in order to implement the national action plans that enable due diligence instruments or due diligence regimes to be put in place requires governments to align and to look at coherence across their suite of policies and suite of legislative practices. And so there is a transformative process in place for governments at the same time. I'm just conscious of time. I've got one more example, which is a slightly different sector, really looking at India and how very provincial forestry cooperative was able to bring about deregulation of a certain part of the forestry value chain through the use of free, prior and informed consent. So essentially what that saw was advocacy and coalition building around a particular part of the value chain for non-timber forestry products, and bringing together various stakeholders across the value chain in order to understand where the rights moments were, where the opportunities for forestry workers and their families to make decisions about their participation and their benefit from the sector. And that advocacy and that process saw in the end result was a national deregulation of one of the components of that value chain. I think that was using free, prior and informed consent, as well as various human rights impact assessment methodologies. So both of those examples are fairly micro on the one hand, but I think what they enable is thinking slightly outside of the box of how to use long-standing existing processes and mechanisms in ways that meet local needs and that meet local agenda and find the middle ground. But what they both do is, what they both did, was shine the light, that they brought transparency and accountability to spaces that are so traditionally fraught with being opaque and being invisible and being secret. And for me, I would say that certainly in supporting work around the world that utilises due diligence mechanisms, that's one of the biggest hurdles, I think, is being able to access, being able to see, being able to interrogate that which has been hidden for so long. I think, Anita, that's enough for me, and I'm looking forward to seeing, I guess, some more of the specific nature of where people are thinking about this. Thank you.
Thank you so much, Dawn, and again for providing some useful examples, and I really appreciate your talking about localization and contextualization and how that's important to anything that's going to be effective in terms of lawmaking and regulation. Our last speaker will bring us into the international realm and thinking about what's happening in Europe. We're pleased to have Francesco Ponzoni, who's a program manager for civil society, gender, human rights, and health matters for the Delegation of the European Union for the Pacific. And so, Francesco, you're going to provide us an update on what's actually happening in the European context with the Union. So thank you very much for joining us today.
Thank you, Anita, and thank you, Tevita and Dawn, for your fantastic presentations, which assist me in mine as well. I won't have a PowerPoint presentation. I will try to keep the audience engaged through my words. I hope you can hear me loud and clear. I think so. Okay, perfect. So through my presentation, I'd like to provide you an insight on the establishment of mandatory human rights due diligence regimes by the European Union as a leading player on this front. I'd like also to highlight some lessons learned on how human rights due diligence could respond to business and human rights challenges, as well as the methodology used to bring about the shift. And finally, also to elaborate a little bit more on how these new obligations under the due diligence regimes have an effect on the entire supply chain, upstream and downstream, in and outside the European Union. The European Parliament passed a resolution on 10 March 2021 with specific recommendations to the Commission on corporate due diligence and corporate accountability. The members of the Parliament wanted to send a clear message, and loud and clear message. Companies must no longer cause harm to people and planet with impunity. The resolution has some key elements that I'd like to list. First, the due diligence requires companies to identify, address, and remedy their impact on human rights and the environment throughout their value chain. Rules should apply to companies operating in EU internal market, including those from outside the EU, which is a key element of concern for the Pacific region. Sanctions, another key element for non-compliance and legal support for victims of corporation in third countries. Ban on import of products linked to severe human rights violations, such as forced or child labor. So the Parliament paved the way for a new EU law that requires companies to address human rights and environmental standards within their value chain. So with this sort of preliminary elements, I'd like to now focus on the sustainability and the good governance. Binding EU due diligence rules would oblige companies to identify, address, and remedy aspects of their value chains. All operations, direct or indirect business relations, investment chains that could or do infringe human rights, including social, trade union, and labor rights, the environment, contributing to climate change or deforestation, for example, and good governance, such as corruption and bribery. Members of Parliament of the European Union, in their resolution, stressed that due diligence is primarily a preventive instrument that requires companies to take proportionate measures based on the likelihood and severity of the impact, the sector of activity, the size and the length of the value chain, and size of the undertaking. So bringing about the change beyond EU borders, which is another element that I'd like to stress because it's of importance for this forum. Companies that want to access the EU internal market, including those established outside the EU, would have to prove that they comply with environmental and human rights due diligence obligations. EU Parliament calls for additional measures, including a ban on importing products linked to severe human rights violations, such as forced or child labor. EU trade agreements, like the EPA, so the Economic Partnership Agreement, which sees Papua New Guinea, Fiji, Samoa, and Solomon Islands committed, should include these aims in their trade and sustainable development chapters. In order to guarantee effective reparations for victims, I've seen over the day that we focused rightly on victims. So in order to guarantee effective reparations for victims, companies should be held liable for their actions and be fined for causing harm or contributing to it, unless they can prove that they have acted in line with due diligence obligations and taken measures to prevent such harm. The rights of victims or stakeholders in third countries, meaning outside the European Union, who are especially those vulnerable, would also be better protected, as they would all be able to take companies to court under the EU law. There is a broad scope and help for SMEs. To create a level playing field, the future legislative framework, which the way was paved through this resolution on due diligence, should be broad and apply to all large undertakings governed by the EU law or established in the European Union, including those providing financial services. The rules should also apply to publicly listed SMEs and high-risk SMEs, which should receive technical assistance to comply with the requirements. Now, to bring this resolution to light and to concrete actions taken by the European Union, I'd like to shed a light on two proposed regulations that the European Commission, the executive body of the European Union, proposed quite recently, last week. So the European Commission, and this is the first of the two regulations that I'd like to speak about today. The EC proposed a law on Wednesday, the 17th of November, aimed at preventing the import of commodities linked to deforestation by requiring companies to prove their global supply chain are not contributing to destruction of forests. Failure to comply could result in fines of up to 4% of a company's turnover in an EU country. This is a major element because we are hitting companies on their economic interest, which is one of the biggest instrument for compliance. The law proposed by the European Union's executive body sets mandatory due diligence rules for importers into the EU of specific commodities: soy, beef, palm oil, wood, cocoa, and coffee, and some derived products, including leather, chocolate, and furniture. Many European companies operate in countries where environmental abuses are rife, but there is currently no EU-wide requirement for them to find and fix risk to environment in their global supply chains. So why is the EU acting on global deforestation and forest degradation? I've seen examples of this over the course of this morning. The main driver of deforestation and forest degradation is the expansion of agricultural land, which is linked to the production of commodities we import as EU, such as soy, beef, palm oil, wood, cocoa, and coffee. As a major economy and consumer of these commodities linked to deforestation and forest degradation, the European Union is partly responsible for this problem. It wants to answer the strong call of European citizens to lead the way to solve it. The Commission therefore proposed a week ago a regulation to minimize the EU-driven deforestation and forest degradation, taking a very concrete step to tackle these issues. By promoting the consumption of deforestation-free products and reducing the EU's impact on global deforestation and forest degradation, the new rules are expected to bring down greenhouse gas emissions and biodiversity loss. There was a public consultation launched by the Commission for this legislative proposal, gathered more than 1.2 million responses, the second most popular in the history of the EU. And this is just to show the overwhelming support from European citizens for this EU action to tackle deforestation and forest degradation. How serious is the problem of deforestation has been addressed through different presentations. But what are the main actions proposed in the regulation? The regulation sets mandatory due diligence rules for operators which place specific commodities on the EU market that are associated with deforestation and forest degradation. Its purpose is to ensure that only deforestation-free and legal products, according to the laws of the country of origin, are allowed on the EU market. Operators will be required to collect the geographic coordinates of the land where the commodities they place on the market were produced. This strict traceability is meant to ensure that only deforestation-free products enter the EU market and that enforcement authorities in member states have the necessary means to control that this is the case. A benchmarking system operated by the Commission will identify countries as presenting a low standard or high risk of producing commodities or products that are not deforestation-free or in accordance with the legislation of the producer country. What would be the main benefits from this regulation? The aim of these new rules is to prevent deforestation and forest degradation, as mentioned earlier. This would also mean a reduction of at least 31.9 million metric tons of carbon emissions to the atmosphere every year due to the EU consumption and production of the relevant commodities, which could be translated into economic savings of at least 3.2 billion euros annually. How was the scope of this regulation defined? 6 commodities, the one that I mentioned earlier, were included in the scope. These have been proposed based on the findings in the impact assessment of the initiative. This analysis aimed at selecting, building on scientific data and previous research, the commodities through which European production and consumption has been contributing the most to global deforestation and forest degradation. Based on the mentioned findings, a cost-benefit analysis was conducted to further reduce the selection and define where an EU policy intervention could be more efficient.
And Francesco, I should just say, if you just have a minute or two, because just in terms of leaving time, there are a lot of questions coming in the chat.
Sure. So let me just clarify how the due diligence system works in practice. Then a quick mention on a second regulation, and then the floor will be open for questions. The new rules will require operators that place relevant commodities or products for the first time on the EU market to exercise due diligence in order to be able to ensure that. So first, those commodities and products have not been produced on land deforested or degraded after 31st December 2020. So there is a specific date. They have, second, these commodities have been produced in accordance with the laws of the country of production. So not meeting either of the 2 requirements will result in a prohibition to place those products on the EU market. So let me skip part of the presentation and just go to the second regulation I just wanted to mention today, because it's for me a key element for this discussion. The European Commission on the same day last week on Wednesday proposed a revamp of EU rules on waste shipments to make it harder for member states to offload their trash into poor countries. Another important action from the EU side to address specific issues. The proposed legislation, which needs, of course, approval from the European Union's member states and the European Parliament, is part of Brussels' plan to reduce pollution and ensure materials like plastic, textile, and metals are reused and recycled rather than thrown away. The goal is to make the EU take a greater responsibility for the waste it produces. That's not the case today, and that's what needs to be done. This is also the words of our EU Environment Policy Chief, Virginijus Sinkevičius. The EU last year exported around 33 million tons of waste, around half of which went to poor non-OECD countries with weaker waste management rules than the EU, effectively shipping EU pollution abroad. So again, we had a resolution in March this year, and which was followed right away by 2 important proposed regulations from the EU Commission to tackle this important sector. Thank you very much for your attention.
Thank you so much, Francesco. And again, thank you to all of our 3 speakers. I'm afraid, unfortunately, that our 4th speaker from UNDP wasn't able to join us today, but we'll move into the Q&A. I think we'll open up the local hubs again so that if anyone wants to ask a question live, but we already have many in the chat and Q&A. So I'm going to go back to Tevita. Tevita, maybe we can begin with you. We have a few questions for you. One related to your example in your slides, and one question from Judith Preston. Was there a detailed environmental impact statement prepared before the decision to allow the gravel extraction project to go ahead? So maybe you can talk about what happened before the project was approved and what you see as the weaknesses. And a second question for you, Tevita, from me, which is you support the idea of mandatory human rights due diligence and show us why it matters. What do you think should be required in terms of consultation, both with Indigenous communities, but with anybody in terms of being part of the law? So over to you, Tevita.
Thank you, Anita. As you all know, EIA is part of, is necessary. It is a legal requirement here in our development projects in Fiji. What I highlighted there is the gap of mandatory human rights due diligence. Because if those measures were put in place, I think our EIA would be better. It would have addressed issues like women, children, cultural rights, indigenous rights, environmental rights, all the UNGB principles. Because we went through all the EIA, that was missing. And with this coming in, this could improve our mechanism of development, because we need development, but at the same time, it has to be sustainable and it has to be done in a much more transparent and inclusive way. In terms of the second question, how can we better improve in terms of community involvement? This kind of platform is really important. For me speaking here, I also speak for the Oceania region for justice and peace, integrity for creation. This impact how we carry out our work on the ground, because we are locally engaged but globally connected. So this kind of network help us do our work on the ground, because we are not an isolated case. We are connected to throughout the whole globe in similar cases. So this kind of does help connect us to other regions and other world, other voices, and it make our issue a common issue for our common home.
I'll come back to you with some additional questions. Dawn, I'm going to move to you for a minute. And there are a couple of questions that were directed at you. You answered one of them, but maybe for the benefit of everyone, can you provide more information about the example that you mentioned in India in terms of creating free, prior, and informed consent among different stakeholders? So maybe speaking to the organization that led this effort and what methods they use. And then we're hearing in the chat and the Q&A a lot of interest in the UNDRIP. And the question there is, when you have a country or a state that hasn't yet affirmed this convention, what are the ways in which you can still bring about those kinds of principles in practice? What are the other mechanisms? So Dawn, over to you.
Thanks, Anita. I'll start with India. I did provide a really quick answer. I thought I had a report ready to share with you all that explained it, but I couldn't find it. So apologies, I'll keep trying to find it. What's interesting, I think, about the India example is that free, prior, and informed consent isn't a part of their national legislation process. So they might be a signatory. I'm not sure whether they're a signatory to the UNDRIP or not, but free, prior, and informed consent certainly isn't recognised. And so why that example for me is significant is because the use of free, prior, and informed consent as a process is effective and useful, even if free, prior, and informed consent isn't embedded into national legislation. So the details of the India example, some of them are too micro for now, but essentially it was a local, a very contextualized, informal in nature governance group. So it was a formal governance group, but utilizing informal and cultural governance processes that started, I believe, the idea of being able to reconceive or reconsider their access to markets. And it was because I think there were some resettlement processes that were about to take place. And so the civil society started to look at what was available to them in terms of rights processes that they could use to effectively advocate around the resettlement process. And they came across free, prior, and informed consent. And part of the free, prior, and informed consent process is about how to mobilise, how to represent, how to inform all of the players in the value chain, in the process of the issue at hand. And so for the forestry example, that was the decision-making group, the people that held the local power for that decision-making mechanism, the forestry workers themselves, the communities that surrounded where the activity was taking place, those that would be impacted by the downstream impacts of it, and the people that were purchasing the products. and then the local government and the national government representatives. And so the triangulation of stakeholders was, I think, what brought significant power, but it also brought transparency and accountability for every single step of that process. In terms, so I think part of the answer then to the second question is around free, prior and informed consent, I believe, is actually only in 2 or 3 countries in national legislation. I'm from Australia, as you can tell by my accent, and it's only in one part of the country in Australia. There is free, prior and informed consent legislation in the Philippines, and maybe 1 or 2 other places. Where it sits in some countries is in some of the environmental protection spaces. There might be provisions relating to free, prior and informed consent. Certainly what we've seen in countries like Zimbabwe, in certain parts of Latin America, that is where there can be really significant movement around how to apply free, prior and informed consent. And I think that the protections for the environment in the raft of business opportunities is certainly a place, I think, that I've heard some conversations for the Pacific, certainly around deep sea mining. If free, prior and informed consent is coming up, it's already a strong conversation in the fisheries communities. Same with, I haven't seen the traction for logging. So certainly in a region where free, prior and informed consent hasn't been embedded in legislation, there certainly are some very strong critical moments, I think, where it as a due diligence mechanism could be applied. That is a very academic answer, I'm sorry, but it's such a deep conversation.
No, and I thank everyone, and I see Simon in the chat has provided his perspective on sort of really first training resource owners to deal with companies. I'm going to pose a question to all 3 of you, but then go to Francesco for some specific questions to him, but ask Tevita and Dawn and others who want to join, especially from the hubs, to join in this conversation, which is there are a couple of questions, a lot of questions around FPIC and UNDRIP, but also questions around remedy. And so there was a mention of, for example, BSR, which is an advisory group, made some recommendations around remedy, I think in PNG, that didn't lead to anything. So questions about how can human rights due diligence as a process address that issue? And there's a second question about access to remedy, about sort of large transnational companies using delay tactics to never provide remedies. So Tevita and Dawn, maybe you can think about the remedy challenge, and others from the hubs or who want to participate in the discussion to also join in, because I think we all have a shared interest in that question. So Francesco, over to you. One of the questions was asked, and I think this is one about the EU, but it's really about anywhere, is has there been, you mentioned all of these different efforts to deal with human rights due diligence in the EU. What about small and medium-sized enterprises? Has there been pushback and concern from these smaller companies around having to comply with these new regulations? So maybe you can speak to that. And a second question, really, which relates to, you spoke about how, the EU is committed to, helping deal with human rights issues, not only within the EU, but really externally as part of these different requirements. So what kinds of technical cooperation and other things do you see coming forward to really realize the benefit of these regulations in places in the Pacific, but anywhere? So to you, Francesco.
Thank you very much, Anita, and thank you, Need, also for the question, which helped me sort of address a broader question. How will the Commission, so the European Union, support partner countries, so not only the private sector, but partner countries abroad, to ensure that the uptake of the new rules? Of course, new regulations brings specific questions in terms of institutional capacity to absorb these new regulations, but also the private sector capacity at different levels, and of course based on the different sizes of the private sector involved. So the Commission has pledged €1 billion to facilitate protection, restoration, and sustainable management of forests in the partner countries for the benefit of people, climate, and environment. The European Union is committed to help partners at different levels to reduce deforestation and forest degradation by supporting them to strengthen forest governance, develop legislation, and this is of course the government, the institutional side, and foster capacity. And this is also relates to the specific questions with SMEs. The forest, there is a specific tool that was conceived to address that specific question. The Forest Partnership. It's a new development cooperation tool which tackle deforestation as one of its objectives. So acknowledging that one size does not fit all, this specific and tailor-made partnership with countries, with partner countries, will be sort of focusing on partner countries' needs. So the attention will be paid to increase the transparency of supply chains while taking into account the rights of forest-dependent communities, which is one of the elements that were raised with the presentation of Tevita as well, I remember, and indigenous people, as well as smallholders' needs. In addition, the Commission will engage in bilateral and multilateral discussions on policies and actions to halt deforestation and forest degradation. So to make a long story shorter, there was a clear intention from the EU to sort of bring some concrete responses along with a new legal framework, along with a new regulation. So the concrete response was the making available €1 billion to facilitate the institutional and the capacity building of the stakeholders. Thank you. And I hope I answered the question.
Great. Thank you, Francesco. And Tevita, back to you. I have another question for you. There was a question asked about what role do local or cultural protocols play in the way in which communities deal with or structure agreements like resource sharing or others with the governments and with companies. And then also your perspective on issues of access to remedy, which I think, as you can see from the discussion, many people have questions about. How do we make this real?
For us in Fiji, our resource is communal based for indigenous people. It's the resource belongs to everybody. In terms of land, a 60% signatory or agreement is needed to be signed. But for foreshore and sea, its own tribal, meaning only the signatory of the tribal leaders are required. So in terms of these processes for obtaining an EIU or an agreement, if the development is carried on land, 60% of the landowners' agreements are needed. But for foreshore and mining deep and for foreshore, it's only the tribal leaders and their consent. So for me, in terms of the remedy, the initial, we tried in the UPR in 2019. That was the first way of trying to get some sort of, because our government is not listening too well to us. So we tried UPR, the Universal Periodic Review, in 2019 to bring up our issues for remedy. Now that mandatory human rights due diligence is here, and EU, and if we can incorporate that in some real ways in how we can put it on the ground, like in our EIA, customary rights, for customary rights of the people to be included, so they can be, the remedy can go directly to them. And also communities that will be impacted, because only the communities that are signatory or landowners, they have the right of remedy. But other communities that will be impacted because of the other communities' decision must also be taken into account, as I've said in the gravel extraction and also in the black sand mining, and also in the deep sea mining, which is also coming in for Fiji.
Thank you for that. And Dawn, over to you again for, again, your perspective on the remedy piece. And again, we've heard questions in the chat in the Q&A, but if anyone for the hubs would like to answer or have a reflection live, please join in. And Dawn, over to you, remedy, and also a question about, do you think that binding rules either in the European Union or locally in the Pacific will be helpful to dealing with human rights concerns?
Thanks, Anita, and thanks everyone for the questions and comments. It's such an important conversation. In terms of remedy, there's three things I really quickly wanted to cover, and I think the elephant in the room whenever we talk about anything to do with due diligence and business and corporate responsibility are the countries and the players that are never going to front up to the table, and we all know who they are. So the remedy conversation, I think, often falls into that place, that camp where we cannot access information. There is no company registration details. There's no public record. There are no nothing accessible in terms of engagement with a company in order for grievance or for remedy to be pursued. And so accountability and the, I guess, the liability that the mandatory human rights due diligence processes are trying to surface fall short time and time and time again. So, I think that's one of the biggest disappointments in terms of global corporate responsibility. The second thing is strong critique has been given throughout the last number of years to the UN guiding principles around how to separate out the obligations for companies relating to one, the obligation for implementation, and two, the reparation for harm. And so I think what it is good to see coming into a bit more clarity, but where I think needs a bit more attention and focus, is that reparation space, and what are the I guess the requirements for companies in particular areas when it comes to remedying for harm, what grievance mechanisms or complaints processes are going to be effective, where resources need to be, committed to that. And again, I think for me that really fails or succeeds at the agreement making process. It's very hard to retrofit that to a business agreement. And then finally is what we're seeing some success, but certainly a lot of research and interest. And I think there's a bit of a climate change angle here, is around assurance and insurance. So both assurances and insurance mechanisms for companies to be committing a percentage of an agreement or percentage of revenue to have assurance funds, I guess, for either rehabilitation environmentally or for harm that's caused by the activity of that company. Certainly, there's some examples I think that I could provide around where that is being considered. I'm not entirely sure where it's been tested, but it's certainly being considered as an opportunity for remedy. In terms of the binding rules, again, I think that comes back to my first comment then around, there is just a whole segment of the business community that are flagrantly flouting any rules or any requirements for human rights protections. And so some of the most significant human rights abuses that we've been seeing are almost impossible to bring to account or bring justice towards, even in the presence of some strong legislation or strong protections. So that I think is a big challenge for the mandatory nature of any due diligence process. But I do think that we've certainly seen some successes. there's some strong Latin American cases of where the binding nature of legislation or the binding nature of due diligence has seen some really strong human rights outcomes. And I'm sure that a number of you in this forum will be able to give examples from the Pacific context. I think that will do from me.
Great, thanks. We just have about 9 minutes left, so if there's any last question, but I'll ask Francesco now. There's a question from the floor about, outside of deforestation, does the EU have partnerships with countries or other frameworks to deal with remedy or grievances in the mining sector or in other sectors? So maybe you could talk a little bit about remedy, and then we'll go back to Tevita and to Dawn for their final reflections as we close this session.
Thank you. Thank you for the question. We do have, what I mentioned before was the economic partnership agreements with some of the Pacific countries. Those trade agreements entails some elements in terms of vetting processes and filters, if you want to put it this way, which sort of help the European Union to vet and assess the quality of products that are exported to our EU market. And coming back to remedy, I think regulations and legislations are useful only in case they apply specific mechanisms that go to the right direction. Meaning, if we have legislations that apply rules on the access to our market, then I think we are on the right path. For one reason, because as a former human rights officer, I've seen that stakeholders are often moved by economic interest. And if we manage to hit this economic interest, we manage to sort of push these actors to comply. And sometimes that's the only way. So if we look at the broader picture, I see that these regulations will have a huge impact because of this specific approach, hitting economic interest. But I see also the weakness of this approach if the global scenario doesn't align. Meaning, if other actors at the international level do not apply the same regulations, then we will see a competing mechanism that will hamper our regulations. So again, I believe that regulations have a sense when they sort of touch economic interests, which are the driver of the stakeholders, private sector and institutions. But these regulations can have a real impact only if there is a broader alignment at the international level.
Thank you, Francesco. As we wind down the session, we have two hubs that would like to make comments or ask questions. So let's go to our hubs, and we might have time to go back to the panelists for quick reflections to close out. But as we can see, many of these issues are going to continue to be discussed throughout the whole forum. So thank you for a lively discussion. So we'll turn to the Vanuatu hub. So Andrina, please, welcome.
Much for the opportunity. One of the questions we would like to raise is in terms of the EU requirement. We find that the processes for accessing funding for simple people or civil society organizations in Vanuatu is very difficult. So is there any provision to make it a little bit simpler so that human rights defenders or institutions working in the field of raising awareness on good governance ethics and integrity standards can continue to work in that arena?
Thank you.
Thank you. Thank you very much, Andrina, for the question. This is a long-standing issue, sort of this big dilemma, access to EU funding vis-a-vis our very complicated and structured requirements from a financial point of view and a reporting point of view. What I can tell you is that this is an issue that is actually debated within the European Union, and especially for this delegation. We are actually working on specific financial instruments that assist CSOs to sort of comply with our requirements and to assist them to, in terms of capacitating these NGOs, civil society organizations, to make it through this daedalus of rules and regulations. So to answer your question, yes, there is a clear understanding of the problem. We do realize that most of the small size NGOs in the region are not able to access our funding for the reasons that you actually mentioned. What we are trying to do is to find the right financial instrument to address this issue, and also to make sure that there is capacity building initiatives behind to support this new trend. I hope I responded to your question. Thanks.
Thank you, Francesco. And Tevita, we have just 2 minutes left, so maybe a 1 minute closing from you before we close out the session. Tevita?
Thank you, Anita. For me, I think one of our strengths is in our dialogue. If we can keep continuing communication, because if we do keep our issues open and keep on deliberating on them, and with government and NGOs, community level, it keeps open pathways for development. Because I find most of the time that we are against the government, we are against cooperation. But if we, in our context, talanoa means to speak openly, address issues, hear each other's voices. Let's keep an open mind. We can work around the issue because there is always a solution if we keep our talanoa open. This is a great way forward to keep our conversation alive, keep our issues at hand, and address them as with all the policies and all, like mandatory human rights diligence can really bring in a lot of good effects if we keep on working on it and not on using the conflict side to address our issue.
Thank you so much, Tevita. And again, please join me in thanking our panel for their insights and reflections, but thank all of you in the chat and the Q&A, many questions, but many ideas. So I think it's a good start to the forum. But I want to close. I'll hand it back to Robert. But first, let me thank our interpreters for their excellent work during this session. And I wish you all a productive forum. So Robert, thank you, and back to you.
Thank you, Anita, and thanks to all the panel members for a highly interesting discussion. I think it's really great to see all the questions coming in and to see the back and forth. That concludes the session, and we'll now take a break for lunch. But please do rejoin us for the second session, which will be on the role of national human rights institutions in business and human rights, sharing experiences, challenges, and good practices, which will take place after lunch at 1:45 Fiji time. So closing for now. Thank you very much.